Hi, everyone. Thank you for joining us for our last session in the MEDLAW Learning Below the Surface series. It's been a pleasure to be able to provide this education to the legal community, and I hope these courses have been helpful to everyone. Today, we have a very important lecture regarding domestic violence in custody cases and how it is critical to implement the current research in order to further protect children. We have two amazing speakers with us today that I'm honored to introduce. Our first speaker is Barry Goldstein. He is a domestic violence author, speaker, advocate, and expert witness. He worked 21 years as an instructor in a New York model batterers program and has written 6 books regarding domestic violence and child abuse in custody cases. He has given many presentations on the current scientific research that addresses the issues in family courts, including 4 presentations on ACEs and Saunders at a national convention of the American Psychological Association. He was also selected as one of the leading experts to participate in a 3-day roundtable discussion co-sponsored by the National Council of Juvenile and Family Court Judges of the Office on Violence Against Women in the U.S. Justice Department regarding evaluations in domestic violence custody cases. In addition, Barry has been a speaker every year at the Battered Mothers Custody Conference in Albany, New York. He's currently a member of the Domestic Shelters Advisory Committee and a consulting expert for the Center for Judicial Excellence. Thank you so much for being with us here today. And then Veronica York, she is a domestic violence survivor, certified in high conflict divorce coaching, and a domestic violence and child abuse custody expert. She has advanced training in family law mediation, writes articles, and performs presentations on the topic of contested custody and domestic violence and child abuse cases. She helps to educate family court professionals on current scientific research that shows standard court practices are harming children, the misuse of parental alienation by abusers, and the tactics of post-separation abuse in the family court system. So I want to thank you both for being here on this crucial topic, and I can send it over to you.
Okay, thank you, Dr. Okeson, and I appreciate the work you've done to put this together to combine the expertise of the medical community with the legal community, because I think that is very much needed. And I know that you did presentation about ACE, and we're going to touch a lot on ACE, but we're going to focus on specifically how that applies to child custody cases. And, I find the ACE research just really exciting. When I do presentations, I like to compare the ACE study to the 1964 Surgeon General's report linking smoking and cancer. Because what we as a society did, all different parts of society, took a role in discouraging smoking. We didn't eliminate all smoking, but we dramatically reduced it. And in doing that, we reduced cancer and heart disease. We saved millions of lives and trillions of dollars. And we can do the same thing with the ACE research. For thousands of years, what we now call domestic violence and child abuse was tolerated. Many of you would remember that several years ago, many NFL players were arrested for crimes involving domestic violence and child abuse. And many of the players truthfully said that they didn't think they did anything wrong because they were just doing what they had witnessed growing up. And the point is that our present rate of cancer, heart disease, diabetes, mental illness, suicide, and so many other health and social problems are based on our long tolerance for domestic violence and child abuse. And the opposite is also true. If we take steps like we did with the Surgeon General's report to reduce domestic violence and child abuse, we can dramatically reduce those medical and social problems. We can increase our life expectancy to a great degree. We would again save millions of lives and trillions of dollars. And I had the privilege of working with Dr. Vincent Felitti, who is the lead author of the original ACE study. He helped me to write my ACE chapter in my Quincy book. And as you might imagine, with medical research, his research was originally used by doctors to diagnose and treat patients. But Dr. Felitti now believes that um, prevention is the best use for his research, particularly in the family courts. Okay, I'm ready for the next one. Um, so the the cases in custody courts, domestic violence and child abuse cases, these are really the most important, the most consequential decisions that courts make. And I think that means that, we should pay more attention, we should use more resources to make sure that these cases are decided in a good way. These are the cases where children, adult victims, judges, lawyers, law enforcement, and others die. These are the cases that destroy children's lives. These are the cases that are painful, unpleasant, and ones that make judges uncomfortable. But the good news is these are cases that the scientific research that we're going to speak about today, that has been discussed throughout the series of presentations, we can use that research to do two wonderful things: to make the work of judges and other court professionals easier when they face domestic violence and child abuse custody cases, and most important, to improve the lives of the children. Veronica?
Hello, everyone. Thank you so much, Dr. Okeson, for having us today. I wanted to talk about context, which is one of the most important factors in domestic violence custody cases. Most custody cases are, as you know, handled more or less amicably. It's only about 3.8% of cases that require trial, and often much more. And 75 to 90% of these cases are really domestic violence and child abuse cases. And in these cases, courts tend to jump to high conflict approaches without really determining the domestic violence or child abuse involvement in the case. And high conflict approaches are often mistaken in domestic violence custody cases because a lot of the practices are biased in favor of abusers. One of which is creating a false equivalency between an abuser and a victim. The goal in most high conflict approaches is to force shared parenting, and research shows us that shared parenting is inappropriate in domestic violence and custody and child abuse custody cases. So these cases really need to be treated very differently from other custody cases, and they're not being done so in the courts right now. Most of the time, courts have heard through their careers that children do better with both parents in their lives. And this is true when both parents are safe and loving parents. It is not true when one of the parents is an abuser. The good news, though, is that we now have a very specialized body of research and expertise that can help courts protect children in these types of cases. And that's what we're going to talk to you about today, starting with ACE. Barry?
Yeah, you can just switch to the next.
Do you see the next slide?
Not yet. Now I have. Okay.
Okay.
ACE really goes to the essence of the well-being of children, which is why it really belongs in child custody cases. And ACE found that children exposed to domestic violence and child abuse will live shorter lives and face a lifetime of health and social problems. And very importantly, most of the harm is not any immediate physical injuries. It's living with the fear and stress that abusers cause. And that means that approaches that refuse to consider older incidents of abuse, that focus only on physical abuse, are a mistake. Because what we need to focus on is reducing the fear and stress in the children. And contested custody cases are often the last chance to save children. As part of the research in my Quincy book, I interviewed medical doctors working with the ACE research. And I asked them what I think is the most important question. When children have been exposed to multiple ACEs, is there something we can do now to save the children from the awful consequences? And their answer was yes. But the courts need to take very different actions. They need to make sure that the safe parent has control over health decisions so the children can get the help they need. And they need to limit abusers to supervised visits until they can change their behavior, because otherwise we can't save these precious children. And so fundamentally, ACE tells us that many of the standard court practices that were developed before we had the research are not working well for children, and we need to change these practices. Veronica?
So the second most important body of research that we use for these cases is the Saunders study. Saunders is out of the National Institute of Justice in the U.S. Justice Department, and it was a study to assess the domestic violence knowledge of judges, lawyers, and especially evaluators. It's one of 3 government-sponsored studies that found serious problems with evaluations in DV custody cases. One of the most important things that Saunders found is that court professionals need more than just generalized knowledge of domestic violence and child abuse. They need specific training in 4 areas. And those 4 areas are screening for domestic violence, risk assessment, post-separation violence, and the impact of domestic violence on children, which is ACE that Barry just talked about. Without this specific body of knowledge, courts tend to focus on the myth that mothers frequently make false reports and unscientific alienation theories. One of the things in Saunders is that Saunders found domestic violence evaluators are not screening properly for domestic violence. When asked how they were screening for domestic violence, the majority said they were using psychological tests. And these tests tell us nothing about domestic violence and child abuse. What Saunders found is that we need to have a multidisciplinary approach in these cases so we can bring in experts that do have the needed domestic violence knowledge. If we're not bringing in the experts in these cases, there are very harmful outcomes that happen and decisions that are made. One of the most extreme decisions that Saunders found is a section in Saunders that he calls harmful outcome cases. Harmful outcome cases is when a safe, protective mother who is the primary attachment figure for the children is limited to supervised visits or no contact with the child, and they are given custody over to the abusive parent. These outcomes, Saunders says, are always wrong, and we put always in caps, in all caps, which is significant for scientific research because they tend to not use the word always. But these outcomes are always wrong because they greatly increase the risk of depression, low self-esteem, and suicide in children when those decisions are made. We'll go to primary attachment.
Okay. So we find that most court professionals have heard about primary attachment, but a lot of times they don't know this significance, they don't know the details, and so it tends to get minimized. Fundamentally, the parent that did most of the child care in the first 2 years of a child's life is and always will be the primary attachment figure. And this is important because that parent usually is the better parent because they've done a lot more parenting. They know the child better than anyone else. They know the providers. And very importantly, the children tend to look to that parent when they need help. And so practices that try to teach, to try to teach, practices that try to treat both parents equally are a mistake. Children need their primary attachment figure more than the other parent, and taking that away is harmful to the children. Veronica?
Okay, so a very important research that's been happening in this space is on gender bias. There were actually 40 states that did court-sponsored gender bias committees that all showed widespread gender bias in the court systems. Some common examples of gender bias is holding women to a higher standard of proof, giving women less credibility, and blaming women for the actions of their abusers. One of the things about gender bias is that it's done usually unintentionally, and good people engage in gender bias, including women. And because it's done unintentionally, a lot of times when we address it or want to bring it up, people can become defensive. So it's hard to talk about. Although it is a difficult issue to address, as professionals, we definitely need to discuss it more openly because it is affecting the outcomes of these cases. And the research that we've done on it can explain a lot and help a lot in understanding how this is being, how this bias is being used in custody courts. Barry, can you see the next slide?
Not yet.
Okay.
Now I can.
All right. It's kind of a delay, I think.
Okay. So, Richard Gardner concocted parental alienation syndrome, not based on any research, but only his personal experience, beliefs, and biases. And his bias included many public statements to the effect that sex between adults and children can be acceptable. And I believe that if judges had known that that was the basis of parental alienation syndrome, they would have been less open to hearing it. But unfortunately, most judges were not made aware of this. Most attorneys for victims didn't know to really challenge this bogus theory. And so it has, become a real poison in the court system. The purpose of parental alienation syndrome was to give a group of professionals something to use to help abusive fathers win custody. Because, normally, if you have the mother who's the primary attachment figure and the safe parent versus an abusive father, the abuser would have little chance to get custody or shared parenting. So they needed something, and that's why they developed alienation theories. And this was the start of the cottage industry. And that's lawyers and mental health professionals who make a large income by using approaches that favor abusive fathers. And the reason this works is that domestic violence is about control, including financial control. And that means in most of the domestic violence custody cases, most of the money is on the side of abusive fathers. So if you're a lawyer or mental health professional and you want to make a lot of money and you don't care about hurting children, you become part of the cottage industry. And it's really dangerous when courts treat cottage industry professionals as if they're neutral experts. Twice, the American Psychiatric Association rejected alienation theories from the DSM, which is the compendium of all valid mental health diagnoses. And think about that for a second. I am not aware of any other court other than the family courts that are willing to consider a theory twice rejected by the leading professional association. And so what happened over time, PAS got a bad reputation, deservedly so. Most people, even those promoting it, recognized it's not a syndrome. And Dr. Gardner died of suicide. And so the cottage industry decided that they wanted to continue using PAS, but they started using it by different names, like alienation, like parental alienation, like gatekeeping. And they wrote new articles to create the illusion that there was some research behind it, which there still isn't. And that's why in the present DSM-5, it was again rejected because there's still no research to support it. It's still based on the original bias theory. Recently, as part of the reauthorization of the Violence Against Women Act, Congress did some research and they added something called Cadence Law. Caden Mancuso is one of over 860 children involved in contested custody cases in the last 14 years who was murdered by abusers. And in Cadence Law, Congress made findings that alienation and reunification programs are not evidence-based, which really should mean that we're not using them. And since this is a new law, a lot of practitioners in the courts aren't familiar with it. And so we want to make people aware that there is now findings in the federal law that we shouldn't be using these bogus theories. We were particularly excited earlier this year with a decision from Oregon. The psychology board there is disciplining an evaluator who's a psychologist. And the evaluator sought to diagnose the mother in the case as having parental alienation. And the evaluator is being disciplined because the evaluator tried to claim that there was other language in the DSM that justified the use of alienation. But in reality, the cottage industry and the male supremacist groups very aggressively lobbied the American Psychiatric Association to include alienation in the DSM, and it was rejected. So that means there is nothing in the DSM that justifies the use of alienation. And this psychologist was diagnosing something that does not exist in the DSM. And what that really means more broadly is that when courts hear mental health professionals claim that there's alienation, if they're claiming that's a mental health issue, as opposed to finding particular facts, not speculation. What that means is all of those professionals really are eligible to be disciplined because they're diagnosing something that does not exist in the DSM. Finally, there's a study called the Meyer study, which is like Saunders from the National Institute of Justice and is peer-reviewed. And they found that alienation theories are being applied in a gender-biased way so that it's only used to help fathers. And what's really going on here is that alienation was created to help fathers. And because mothers do most of the childcare in our still sexist society, court professionals often ignore or don't notice when it's the father doing the alienating. And that means that alienation is being applied in a manner that really violates due process and equal protection. Veronica?
Thank you. So we have child sexual abuse is a big issue in contested custody cases. And it's an uncomfortable subject, but ACE found that we are allowing about a quarter of our children in the United States to be sexually abused. That is a very high number, and a lot of it is due to the way that we look at child sexual abuse, the way we react to child sexual abuse. And so there are poor practices in looking at child sexual abuse that we want to look at. And one of those is there is a distinction between when a perpetrator is a stranger versus when the perpetrator is a close family member, someone the child knows, like a father or parent. And when the perpetrator is a stranger, the way that we react to child sexual abuse is pretty good. It's immediate. Law enforcement gets involved. They do a thorough investigation. We want to, the goal and the purpose is to get a conviction and to protect the child. Unfortunately, a lot of times when the perpetrator is someone the child knows or a close family relative, especially if they are involved in a child custody case, the purpose is reunification rather than protecting the child, doing a thorough investigation and so forth. There are a lot of reasons for this. One of them is that we don't want to believe that a father or a close relative could do something like this to a child. We don't like talking about it. It's very difficult to prove, especially if the child is very young. They don't typically talk about it. They're silenced by the perpetrator. They won't talk about it unless they're very comfortable with the person. A lot of times they're expected to talk about the most horrible thing that's ever happened to them to a perfect stranger, and if they don't reveal or have an outcry, then they're just not believed. There's definitely a need for specialized experts in this area, especially in child custody cases where there's alleged child sexual abuse. Barry mentioned the Myers study. The Myers study also found that courts disbelieve reports of child sexual abuse 98% of the time when the mother reports the abuse and the father is claiming alienation. And this is even though we have a study called the Bala study that found that mothers only make deliberate false reports less than 2% of the time. And there are reasons for Child Protective to make cases unfounded. And what happens is courts like to assume either the report is false or it's true. But if it's, in order for it to be true, there has to be a substantial amount of evidence. And if there's not, then they automatically go to, well, it's not true. And the mother's coaching or alienating the child, when there can be very possible other likely explanations. And those explanations could be, that the child could have been exposed to pornography or a sexual act. They could have had a boundary violation. The evidence is unequivocal evidence. So there are other likely explanations rather than the two. The least likely is that it's, a deliberate false report. So we definitely want to take a look at those practices that are leading to allegations of child sexual abuse being minimized, disbelieved, or completely ignored altogether. Barry's going to talk a little bit more about child sexual abuse on this next slide.
Okay, while I'm waiting for the slide, let me mention that when we finish, we are going to be open to questions. So if you want to write it in the chat or just have your question ready, we'll be happy to answer them. One of the problems with the court response to child sexual abuse is that they often discredit reports based on non-probative findings. And let me give you a couple of examples. Lots of times, law enforcement won't prosecute because it's very hard to prove something beyond a reasonable doubt, particularly, with a very young witness. And that doesn't mean it didn't happen. It just means that that's hard to prove. Another thing with child protective is that, as Veronica was talking about, very often the caseworker will just take very little time to develop a trusting relationship with the child. And if the child refuses to talk about it, they right away unsubstantiate the case. Most child caseworkers are not, they don't have the specialized sexual abuse knowledge that they need, which leads to disbelieving true reports. And so, and they're overworked. So there's a strong pressure to close cases. So when a case is unsubstantiated, that is not probative to the idea that therefore the report is false or even that it's coaching. And yet very often that mistake is made by court professionals. As Veronica was mentioning, there's this common mistake that if we don't meet a really high standard to prove child sexual abuse, right away court professionals jump to that it must be coaching. And that's often not true. There are many other possibilities. We also face the idea that, a father wouldn't do something so horrible, especially if the father is educated, successful, speaks well, dresses well, none of which is probative. Very commonly, the problem is the failure to develop a trusting relationship with the child, and so we're not getting the information we need. And the normal child response to sexual abuse undermines the ability to believe true reports. Because what tends to happen is the abuser is trying to silence the child. The child doesn't understand what the abuser did to them. They're not sure if they're in trouble, if they did something wrong. And so what they tend to do is they will tell the person they most trust, and they will only tell part of the story to see what kind of reaction they get. And so most of the time they tell the mother. And in a contested custody case, mothers are the least likely person for the court to believe. They're viewed as partisan, and there's the myths that mothers frequently make false reports. So when the mother raises the concern, she's less likely to be believed, even though she's more likely to be telling the truth. And if the mother is supportive and tells the child that you did nothing wrong and we're going to try to protect you, the child may then reveal more information. But aggressive defense attorneys and other professionals treat new information that supports the sexual abuse as if it's raises questions about the validity of the report and that it's based on coaching. And so the standard, circumstances are used to discredit true reports. And so we need to be aware of that. And I guess the point is we need to take a fresh look at how courts respond to child sexual abuse. Best practice would really be play therapy, especially for young children. The children would reveal whatever they have to subconsciously in their play, in their artwork. And the fact is, no parent could coach a child how to play with Legos, how to draw a picture. So it takes away the idea that they're being coached, which is so misused in the courts. And so we ought to really turn to play therapy to find out for sure what's going on instead of try to quickly rule out sexual abuse so we can go on to, more comfortable subjects. Next.
Yes. So the point is we can do better and we need to do better in custody cases, in domestic violence and child abuse cases. And we can do better by bringing in the research and knowing the research and educating about the research. It's significant that a unscientific theory like parental alienation syndrome, which is gender bias and sexist, has more influence in custody cases than Ace and Saunders, which is two peer-reviewed scientific studies from the most credible sources that really go to the essence of the well-being of children. That's why the National Council of Juvenile and Family Court Judges seeks to train other judges on Ace and Saunders. And we really need to devote more resources to abuse cases because, as we mentioned at the beginning, these cases are so consequential, and it's not a place to do shortcuts. A lot of court practices that give, the dockets are full and they don't have a whole lot of time and they try to speed through these cases really benefits the abuser because, as we talked about, context is very important. It takes more time to talk about the research and produce the context that it does to just deny allegations of abuse. So we really need to devote those resources. It will be beneficial to do that. These cases would not continue to come back to court over and over again. It would save time for the court, and it would be helpful for the children as well. The main thing is we need to make the health and safety of children the most important thing in these cases. And that needs to be the goal rather than the goal being to keep an abuser in a child's life. Again, abusers, parents who are abusers and do more harm than good in a child's life needs to really be focused on changing their behavior for them to do more good than harm. So it's really about changing the discussion in these cases to what can the abusive parent do to change their behavior rather than what can the child and the safe parent do to accommodate their abuse. So let's use this research to really take a fresh look, as Barry said, at outdated practices that Ace and Saunders tell us are harming children. Barry, anything to add before we take questions?
No, I think we're good.
Okay. I think we're right on time there, Dr. Okeson.
Thank you so much. That was such a great talk. It is a hard discussion and there's different thoughts, but being able to apply the research in this way, I think can be very informative for people, and hopefully it was. Thank you so much for coming. I don't see any questions in the chat. I can give everyone a few minutes to formulate any if they have. And in the meantime, I will just discuss some other formalities about the CLE credit. I'll be submitting that this week, so you should be able to see that on your board. And thank you so much for coming to all of the lectures that we've had this month. I hope that it was helpful. We'll be sending the post surveys for everyone and the handout as well in emails. And these were recorded, so you can view them later as well. I'll give a few more seconds to see if there was any questions, but that was really helpful. So thank you for those presentations.
If there's no questions right now for us, I do have our contact information on the screen as well. So they can feel free to reach out via email or check out our website if they have, they want to look further into these topics.
Yeah, absolutely. You can email us or them, and we can provide that for you. All right, perfect. Well, I still don't see any, but let me see. Oh yes, hold on. So is the parting shot takeaway for legal practitioners to almost make it so that the rebuttable presumption is that DV claims are to be believed over the claims of alienating or gatekeeping?
obviously, well, in the Saunders study, it talks about the need to screen for DV. And it might be useful for us just to say what that means. Because we think there are four parts to screening for DV. And very frankly, they're not being done in the courts. The first part is to avoid discrediting a true report based on non-probative factors. And let me give you 6 of those. The victim leaves and returns. She seeks a protective order, doesn't follow through. She doesn't have a police report. She doesn't have medical reports. Someone observes the father interacting with the children, and the children don't show any fear. And so we say, aha, he can't be abuser. And in fact, the children know that he wouldn't hurt them in front of a witness, and so it's safe to play with him. And the 6th one, which is very common mistake in courts, is that they fail to consider that an alleged abuser's good behavior in public says nothing about how he acts in private. And so very often untrained professionals will hear from friends and family that say what a nice guy he is, but they haven't gotten anything probative about how he acts in the privacy of his home. The second thing is we need to ask which parent is afraid of the other. And usually the answer is very clear, but most court professionals don't even ask that question. The third part is to look at the motive of the alleged abuser. And, again, the context is most custody cases are settled more or less amicably because you have 2 good, safe, loving parents. The contested custody cases overwhelmingly are domestic violence cases in which the worst abusers, men who believe that she had no right to leave, go after custody to regain control and to punish her for leaving. And what happens is courts cannot assume based on statistics that usually he is the abuser, but they should at least think about it instead of assuming that the father is acting out of love for the child. And so there are usually evidence in the case, he doesn't pay child support, he's undermining the mother's relationship, he's again interfering with the visitation of the mother, or won't let the children speak with the mother. There's evidence that indicates that his purpose is to hurt the mother, even if he's also hurting the children. The fourth thing is to look for the pattern of abuse. If we look at all of the different types of tactics that an abuser uses, instead of just look at a few physical incidents, there's much more evidence available to understand what he's doing and why there's this fear and stress, which is what ACE is doing. So that's part of it. In answer to the question, if we were to say that, given the fact that mothers make deliberate false reports less than 2% of the time, therefore let's just believe mothers, we'd get a lot higher percentage of cases right, but that would be unfair. I mean, we need to look at the facts in each case. We certainly have to avoid discrediting mothers based on the myth that they frequently make false reports, but we need to look at the big picture. And context is important in understanding DV custody cases. And let me give you a context that almost always is true. During the relationship, the father either wanted or demanded that the mother provide most of the child care. In any other court, that would be correctly understood as an admission by the father that the mother is a good parent, or else he would have sought other child care arrangements. And what happens typically when the mother decides to leave, um, and particularly when she reports his abuse, the abusive fathers respond by going after custody or shared parenting and claiming that the mother is suddenly unfit, usually that she's crazy or she's alienated. And the question that we fail to ask is, what are the chances that a mother suddenly became unfit because the relationship ended and she reported his abuse? Because in the real world, the answer is close to zero. But in custody courts that are not using the research, that are relying on the wrong professionals, that are really biased to try to promote shared parenting, they very frequently come to that unlikely conclusion. And, I think Veronica talked about it earlier, that we really need a little bit more time for DV custody cases to provide the context so that we can understand things and to use the research. It takes longer to explain that, but it would make it easier for the courts to recognize true reports.
It's a great answer. Thank you. Um, Great. I think that if you guys have any other questions, we can email them or talk with them. But I do think that that is a good way to look at it. You have to look at the whole picture and use the research. Oh, wait, we might have one more. So, what does the research indicate about domestic violence in custody cases as it relates to the act of violence perpetrated by mothers against fathers? Seems much of the research covers father violence against mothers.
Veronica, you want to do it or you want me to?
You go ahead, Barry.
Okay. The research is very clear. Most domestic violence is in heterosexual relationships is what men do to women. There are certainly exceptions, but the exceptions are not based on the history. Think about domestic violence is different than most crimes because there was never a time when bank robbery or arson was acceptable. Those were always crimes never tolerated. But a little over a generation ago, what we now call domestic violence and child abuse was acceptable. There were no criminal penalties. And that's important because even though the laws have changed, many people, particularly abusive men, continue to believe that that behavior is acceptable. Batterer narratives suggest that men believe it's wrong for a man to hit a woman, except if she does something that he defines as wrong, or if she is, and you could insert the slur, but all the really lousy, disgusting words that men use about women. And that gives them permission to assault and hurt the mother. And so, to answer your question, overwhelmingly, it's what men do to women because there's a long history of tolerating men's abuse of women or men's discipline of their wives or control over them or the right to make their decisions. So, certainly there are cases where a woman mistreats or assaults her partner, but it's really more often it could be defensive, it could be a mental health issue. it's the exceptions. And, we need to look at them and take them seriously. But to know that it's more often that men abuse women. And, the ballast study that Veronica mentioned, which said that mothers make false reports less than 2% of the time, that same study found that fathers involved in contested custody are 16 times more likely to make false reports against mothers. And it's usually part of the tactic to regain what they think is their right to control their partner. And so, those are the broad information. And certainly any judge has to look at the specifics in the case. We can't make decisions based on statistics, but it's helpful to know the bigger picture, to know that lots of times abusive men use tactics. They will ask for visitation, refuse to take it, and then say the mother's withholding it, or they'll hurt themselves in order to make a false claim of abuse. That's not unusual. And so we need to look at what actually happened. There's a lot of things about domestic violence that are counterintuitive. And that's why it's really helpful. And Saunders recommends a multidisciplinary approach that includes a DV expert. So when you have a potential DV case, a mental health professional is helpful in terms of mental illness and psychology. But if you're trying to determine is there domestic violence or child abuse, you need a DV expert.
Thank you. And the response is very informative. I would love to see new research developed on these issues in same-sex relationships or violence perpetrated by women in these cases, as I have seen an increase of both recently. It is also my experience that men are less likely to report DV, so we may not have accurate data on the frequency of occurrence. And yes, more research to add to the topic and the conversation would, of course, be great and welcomed. Wonderful. Any other questions? Perfect. Well, then I think that we can wrap up. And if you do have any other questions, please reach out. And great discussion. Thank you, everyone. I don't know if Tracy, you had anything that you needed to add.
Yeah, you guys just keep an eye out for an email from me in about, hopefully by the end of the day, but if not, by the end of tomorrow. And I'll have a couple handouts for you guys. And then also, if you weren't able to grab that evaluation link, I'll put it in that follow-up email as well. But other than that, no, Dr. Okeson, I think that was it. Just keep an eye out for that follow-up email.
Perfect. Thank you so much, everyone. Have a great day.
Thanks for having us. Thank you.
Thank you for coming and giving the presentation.